The court calls the case People versus Robin Finney.
This is one of those openings that looks routine on paper, but immediately tells you what kind of courtroom morning this is going to be. Multiple cases stacked back to back, quick roll calls, and a judge who is clearly focused on efficiency. When you hear a request for a brief adjournment for plea negotiations this early, it usually signals two things. First, that conversations are happening behind the scenes, and second, that nothing is settled yet. Notice how bond isn't even being addressed here. That's intentional. When attorneys specifically say they're not touching bond, it often means they don't want to risk opening a door that could make things worse for their client. Judge Simpson's response is clean and decisive. Adjourned, new date set, bond continues. No lecture, no commentary, just control of the docket. That wow reaction you hear afterward isn't accidental either. It reflects how quickly the court moves on, which can feel jarring if you're a defendant or family member expecting more discussion. This opening stretch sets the tone for everything that follows. Rapid-fire justice, high stakes, and decisions that may sound simple but carry serious consequences. As you watch this unfold, ask yourself this: if you were standing there as a defendant, would this speed reassure you, or would it make you nervous about how little time your case seems to get?
Your Honor, Alexis Plumai on behalf of Ms. Finney, who is approaching. Ms. Finney, could you just say your full name?
Yes, Robin Lee Finney.
Thank you. And Your Honor, we are just asking for a brief adjournment for plea negotiation purposes. And I am not asking to address bond.
Shocking. Probable cause conference will be adjourned to July 17, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Wow. Court does call the case People versus Sean Cotton.
APA Richard McDuffie for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cotton, who should be appealing via Zoom.
Mr. Cotton, please state your name.
John Cotton.
Your Honor, at this time, we'll be requesting an adjournment for the client to pay some restitutions toward his offer.
PCC will be adjourned July 17, 2025, 9 a.m. Bond continues. Court does call the case People versus Daniel Franklin.
Andrew Field is appearing on behalf of the people, Your Honor.
Good morning, man. Please, Honorable Court, Kareem Johnson, appearing on behalf of Mr. Franklin.
Your name, sir?
Daniel Franklin.
Thank you. All right, what are we doing on this case?
I spoke with Mr. Johnson. I don't know what has been, I believe he has been tendered discovery, and I think we're just looking to set this matter for an examination.
Is that a correct statement, Mr. Johnson? You'd like this matter set for prelim?
Yes, Your Honor, and we're asking that the prelim be set out a ways. I believe the people will be calling a cooperating witness who is in federal custody because of the likelihood that this witness may become unavailable down the road. I will be asking for the people to present any and all information they have relevant to cross-examination under U.S. v. Giglio.
This is where the legal complexity spikes, and it's easy for casual viewers to miss how significant this moment is. When defense counsel invokes Giglio, they're demanding disclosure of anything that could impact the credibility of a cooperating witness. That includes deals, promises, benefits, or prior misconduct. The reason this matters so much is because cooperating witnesses are often central to serious cases, especially when they're already in federal custody. Judge Simpson listens carefully here, and you can hear the balancing act happening in real time. The court wants the case to move forward, but not at the expense of fairness. There's also an undercurrent of urgency. This witness could be transferred out of state, possibly becoming unavailable. That's why you hear talk about writs and transport logistics. But this isn't just scheduling, it's about preserving testimony that could make or break a case. The humor about West Virginia lightens the mood, but the reality underneath is serious. If this witness disappears, the entire strategy could collapse. From your perspective, does relying on a cooperating witness already facing federal charges make you more skeptical of the prosecution's case, or do you see it as a necessary tool in complex investigations?
And I think the people may need some time to get that. And I don't know if the people are even in possession of the federal indictment in which this witness is cooperating under and giving this testimony. But I would like to have that before exam as well.
Your Honor, I have no problem with that. I have no problem with setting this matter out as the court may remember, Mr. Franklin is being held on another homicide case that is pending before Judge Conlon with a trial date well into the fall. The reason.
So why am I setting it for exam if everything's not ready?
This cooperating witness is currently being held at FCI Milan. The moment we have an examination date, I can give a writ to them. They won't transport him. Otherwise, it sounds like he's going to eventually go to West Virginia, and I'd like to have that writ before the Bureau of Prisons transports him out of the state. So the date,
especially to West Virginia, because people don't come back. No, I'm kidding. I love West Virginia.
I don't know.
Okay.
And so that would be the reason I know, and as I spoke, Mr. Johnson and I spoke yesterday, and I believe we're on the same page.
All right. So how to get accomplished everything, how much time are you guys looking at? I get why you want a date out. I'll set the exam, but
perhaps I don't know what the court's availability is. I'm looking into kind of August.
Mid-August. I can do August 12. I can give you a prelim date on August 12.
That works for the people. That works for Mr. Johnson.
Your Honor, on August 12th, I have another homicide exam in the Lansing District Court.
Gotcha. Well, that's my only set PE date in that date. Did you want me to kind of give you a Monday and that way more flexibility to do that?
August 11th, if the court is available that day, that would be perfect for me, Your Honor.
Monday would be fine, and just for the court scheduling purposes, I wouldn't expect this to be something that would take more than half a day. So
Okay.
that'll be a full day examination.
That's okay. So what I'll do is I'll just put it on my docket. I should have asked, do I have the 11th available? And if we don't pick a jury selection in the morning, so I can set it in the afternoon. Oh, I did set an order to. Okay. Pardon. I can do Monday the 18th. Will that work for you, Mr. Johnson?
I'll be at a jury trial in the Washtenaw County Circuit Court on the 18th, Your Honor.
No way. No, I'm kidding.
The 25th works for me if that works for the court.
No, because I'm gone. Right. Well, August, I know it's going the other direction, but would August 4th work?
I think the August, at least from the people's perspective of getting the information to Mr. Johnson, August 4th would work for us.
Mr. Johnson, August 4th work?
I will be in trial August 4th, Your Honor.
The whole day?
Yes, Your Honor.
Just, all right, give him a Tuesday. I don't know what Johnson's schedule is. I don't know why I'm setting around Johnson anyway.
My other thought is if we could set it on a Tuesday, perhaps that 12th, knowing that we would then get closer to the date and perhaps talk with the court about a skip to move it. As long as I have the date to hold this witness, I don't care if we move it. I can send.
Why don't I do this then? And then this way you can kind of figure it out, and then we can move it up to give you more flexibility in terms of dates, because then we'll be able to figure out my dates a little bit. I'm going to set it on July 22nd. Okay. With the understanding that you guys may have to move it, but then we'll move it on my docket.
That's fine.
Okay.
Yes, Your Honor.
So preliminary examination in person will be set July 22nd, 2025. That's at 12 noon.
This stretch perfectly illustrates how much of courtroom work is logistical chess. Dates move, conflicts arise, jokes get thrown in, but every adjustment serves a purpose. The judge's priority here is securing the witness while still accommodating attorneys' schedules. By setting a date now, even with the understanding it may change, the court locks in jurisdiction and leverage. That's critical when dealing with incarcerated witnesses. For viewers, it might feel like overkill, so much talk just to land on a date, but this is the foundation of due process. Without it, cases fall apart. Judge Simpson maintains control while showing flexibility, which is a delicate balance. Too rigid, and fairness suffers. Too loose, and chaos follows. This moment also shows how much power timing has in criminal cases. Weeks or even days can change outcomes dramatically. If you were a defendant watching your future hinge on calendar availability, would you feel confident in the system or frustrated by how procedural everything feels?
Yes.
So that's an afternoon prelim docket or PE docket for me. All right.
Thank
Thank you, Your Honor.
All right.
Mr. Johnson, I'll contact you early next week and we can go over
Yes, sir.
everything, okay?
All right. Thank you, Mr. Johnson. Court calls the case of the People versus Dave Ellington.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Ellington, who's approaching now. Your Honor, Mr. Ellington will be waiving his right to a preliminary exam. I'd ask if the people would place the offer that was extended on the record. Today.
Your Honor, Mr. Ellington is charged with financial transaction advice. Without authorization. The offer is.
The offer is 2 and a 10. Is that your understanding?
Yes, Judge, thank you.
And sir, you're waiving your right to a preliminary examination?
Yes, sir.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right?
Okay.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Your Honor, we would acknowledge receipt of the information, waive formal reading. My client would stay mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set.
Here we see a defendant waiving a preliminary exam, and that's a decision that deserves attention. A preliminary exam forces the prosecution to show probable cause early. Waiving it often means the defense believes the offer on the table or the strategic position later in circuit court is stronger than what they'd gain now. Judge Simpson carefully explains the rights being waived, ensuring the record is clear. That's not just formality, it's protection against future appeals. Once the waiver is done, the case moves forward fast. Bound over, information acknowledged, plea entered, pretrial scheduled. This is efficiency at work, but it also means the defendant is committing to a longer road ahead. For the audience, this is a good moment to pause and think. Would you waive a hearing that could expose weaknesses in the prosecution's case? Or would you push for every opportunity to challenge the evidence early?
August 8th, 2025 at 1:30 with Judge Simpson.
August 8th, 2025, 1:30, Judge.
No, you're good. This is just your notice.
Oh,
On continue.
Thank you, Judge.
thank you.
All right, I'll finish this.
Court calls case of the People versus Jaleesa McDowell.
Your Honor, Amy Riser is going to be testifying.
Your Honor, Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Ms. McDowell.
Okay, permission to practice is granted.
Thank you, Your Honor. Ms. Dr. Could you say your name for the court, please?
Jaleesa McDowell.
Thank you. All right.
Your Honor, we would like to request the court set a date for exam in this matter, please.
All discoveries complete.
Yes, Your Honor.
People have their witnesses available to 15?
Yes, July 14th.
Yeah, July 15th. Will that work?
Yes. And Judge, I said it should.
Preliminary examination in person will be set July 15th, 2025. 9 a.m. That is before Judge Moore. Esteban.
Thank you. Your counsel has been provided with several of the defendant's jail calls. And we're asking that her calls be revoked at this time. She's actively trying to have third parties contact the minor child in this case to have her recant. So we're asking that her jail calls be revoked and if necessary, a date be set for a hearing.
Your Honor, I've listened to the calls myself, and while in some regards, Ms. McDowell does talk about her case to people, she very rarely makes requests. Her tone is not demanding or threatening or coercive.
Rarely makes requests.
Well, I mean, I'm talking about a request in general, Your Honor. So, but there are a lot of conversations, and for the most part, her tone is not demanding or threatening or coercive in any way. And mostly she's just talking and trying to communicate with her mother, her grandmother, and her cousin and other family members.
But are there indications that not only, because those would be third-party contacts, but is there an indication where in any reasonable fashion it could be read she's making a request for somebody to recant their story?
Your Honor, I believe that in most of the situations and most of the phone calls that we heard, she wasn't making requests as much as just expressing how she was feeling about certain issues with her grandmother and her mother and the people who are taking care of her children right now.
It really doesn't answer my question, but
Yeah,
that's fine.
We did meet with Ms. McDowell yesterday. We talked about that. I will say Ms. McDowell was very candid. We went through some of the phone calls together. Her understanding, she had no intent to disobey the court's order. She's not in any way trying to intimidate or coerce anyone to come to court or to not come to court. Her position is that she has other children involved. She was getting messages that these children are left unattended at her home. She's very concerned about the safety for them. That has now been resolved. After my conversation with McDowell, she even said, I don't plan to be on the phone anymore. I was never trying to disobey the court's order. That was not my intent, but obviously she has concerns for the safety and well-being of other children that are currently, they now are placed with someone that she knows, and she does not have that same concern for their safety and well-being at this time.
If I could, John, provide an offer of proof, just an excerpt from one of the calls.
Yes.
This is the defendant speaking on June 19th, 2025. She's got mental problems. She's got mental problems. Me and Melody don't speak because she done put $300 worth of damage in her house. I think you all will speak up for me and share her stuff too. Like, that's not fair. That's at 2:11 in the call. And at 5:08 in the call, the defendant says, I probably could get her a ride to court like that. I know I can get unintelligible. Who she's speaking with, I believe it's the grandmother. Let me give her a ride. Let me get her a ride. I'll take Talisa out there. Let me give her a ride out there. The defendant, what are you talking about? Is she really coming to the court? And the grandma said, we haven't talked about that. We haven't talked about that. And the defendant responded, no, you got to talk to her about that, Mom.
This is the emotional and legal turning point of the final case, and it's heavy. Jail calls are often defendants' lifelines, but they're also monitored, recorded, and used as evidence. The prosecution's excerpts are short but powerful, suggesting attempts to influence a witness's court appearance. Defense counsel argues intent, tone, and concern for children, painting a picture of a worried parent rather than someone trying to obstruct justice. Judge Simpson cuts through the explanations and focuses on one question. Could this reasonably be read as an attempt to influence testimony? That's the standard, not whether the defendant meant harm. When the motion to revoke phone privileges is granted, it's a serious consequence. Communication is restricted and the defendant's isolation increases. This moment shows how quickly circumstances can shift based on words alone. Ask yourself, where should the line be drawn between concern for family and interference with the justice process?
I could go on and on.
Seems enough for me. Motion to revoke defendant's phone privileges is hereby granted. Defendant's phone privileges are hereby revoked. You can always ask for a hearing on that. All right. Thank you.
Your Honor.
This ruling closes the morning on a firm note. Judge Simpson makes it clear that while hearings can be requested later, the immediate priority is protecting the integrity of the case. Across all these matters, a pattern emerges. The court values efficiency, structure, and clear boundaries. Adjournments are granted when justified, rights are explained on the record, and restrictions are imposed when lines appear to be crossed. None of these decisions exist in isolation. They shape negotiations, influence behavior, and affect real lives outside the courtroom. For viewers, this is a reminder that courtroom drama isn't always loud. Sometimes it's procedural, technical, and quietly decisive. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.